Okay, quick question. Would you rather have someone look through your Google search history or have someone look through your OpenAI chat history? I know my answer. No longer are the days of finding an oddly specific question answered by some Reddit user from 7 years ago. Today, people are turning to AI chatbots as all-knowing confidants, which means those conversations can include incredibly sensitive personal information. So no, you're not the only person using ChatGPT to answer your weird health symptoms or questionable dating decisions. In fact, AI chatbots are on track to replace traditional search engines altogether. Many predict websites themselves will become relics of the past. Even now, OpenAI is testing ways for businesses to display their product data directly into ChatGPT when someone asks for a recommendation, accelerating the shift from traditional search engines to AI-driven discovery. Not only is this evolution a shift in how the general population accesses information, but it also carries serious implications for eDiscovery, data retention policy, cost implications, and energy demands. When it comes to AI being applied in the legal process, we've already seen substantial changes, especially in eDiscovery. eDiscovery refers to the information collection, review, and production of electronically stored information, or ESI, during a legal discovery process. AI has already made its way into this workflow through tools like technology-assisted review, or TAR, which uses machine learning to classify documents by relevance, significantly reducing the time and human labor needed during document review. But there are additional considerations AI is forcing us to examine. Just as internet searches, browser history, and communication log, like emails and messaging apps, reshape the boundaries of discoverable material, AI interactions are now likely to redefine those boundaries again. First, we'll look at, well, for one, what discovery is, and then how it's expected to change. Discovery in the legal process is the exchange of information between litigants, and litigants are just the parties involved in the lawsuit, including both the plaintiff, the one bringing the suit, and the defendant, the one being sued. Isn't it so fun we're being called parties here? Oh, never mind. Anyway, discovery is governed by the rules of procedure. This can include the federal rules of civil procedure, state rules, criminal procedure rules, and the federal rules of evidence. Under the federal rules of civil procedure, it's rules 26 through 37 that are specifically titled Disclosure and Discovery. These rules lay out how parties must disclose information to each other in civil cases. Unlike in civil procedures, in criminal proceedings, there exists a doctrine known as open discovery, which is the idea that the prosecution should provide the defense with everything in the prosecution's file. In theory, this encourages both parties to settle, because if all of the cards are out on the table, then the answer should be right in front of everyone's face. However, in practice, this is not the norm. Prosecutors often resist full transparency due to strategic concerns, fear of witness intimidation, or risks of compromising ongoing investigations. Now, allowable discovery is more restrictive than open discovery because it defines what types of discovery requests or materials are explicitly permitted under the rules of procedure. For criminal cases, allowable discovery is even more restrictive because of constitutional protections like the Fifth and Sixth Amendment. A discovery request is when a party files a formal legal request asking the other party in the lawsuit to provide materials that might be relevant to the case. Materials are potential evidence, like documents, data, and physical objects. Basically anything that might be relevant to the legal case. Because we seek to achieve basic fairness and judicial efficiency, discoverability can be pretty broad. So both civil and criminal use legal filters like relevance, privilege, proportionality, and work product doctrine to evaluate the scope of discovery. The scope of discovery is essentially the amount of discovery the opposing party is entitled to after those limitations are imposed. So let's zoom in on civil proceedings. The limits for what is allowable in discovery is highlighted under Rule 26b(1) of the Federal Rules of Civil Procedure. Discovery regarding any non-privileged matter that is relevant to the party's claim or defense and proportional to the needs of the case. So what is privilege? Privilege protects certain types of confidential communications from being disclosed during discovery. And speaking of, you ever heard of attorney-client privilege? Well, that's sort of what we're talking about here with work product. Attorney work product is all of the materials prepared in anticipation of litigation. This can include correspondence between the attorney and the client, or even communication between the attorneys and other staff. It also includes notes, strategy documents, and research. When it comes to these protected materials, it is extremely important that these privileged documents are not accidentally exposed to the opposing party. Doing so as an inadvertent disclosure may be tantamount or equivalent to a waiver. A waiver is a voluntary relinquishment or surrender of a known legal right. This could apply to attorney-client privilege or discovery. Therefore, if someone accidentally shares information with the other side, they might waive their right to object discoverability of those materials, but only if they fail to take reasonable and timely steps to prevent or remedy the disclosure, as outlined in the Federal Rule of Evidence 502B. Unfortunately, this has happened countless times, especially when it comes to eDiscovery. Electronically stored information, also known as ESI, is every piece of data that is stored or transmitted on, from, to, or through any electronic device. This can also include video, audio, images, text files, word processing, websites, social media, voicemails, phone records, emails, and even computer programming information. ESI is typically classified into two categories, depending on the file format. Natively electronic refers to materials that maintain their original digital form, such as emails, spreadsheets, or database records. Non-natively electronic means material has now been converted into a different format than it was originally created, like a scanned document. This could look like an email copied into a Word document or a printout of a text message. More often than not, courts prefer ESI to be produced in natively electronic formats because admitting documents in native format lets the jury see documents in the way the party created them. This is known as the best evidence rule. Also, there's a high likelihood that the metadata has been preserved, which can be critical to assessing its authenticity. Metadata is the data that gives information about other data. For example, have you ever taken a picture on your phone and noticed it comes out with built-in information like the time, date, and location that it was taken? Then if you were to throw it into Facetune, get it Instagram ready, and then boom, now there's evidence that the photo was edited and which app you use. You're exposed. Because seriously, no one would ever have known otherwise. That's why metadata is so important. It's like an event log of version changes, which, as you can imagine, is the reason why so many cases have hinged on the production of native format ESI. For ESI especially, the proclivity towards native formats goes hand in hand with the duty to preserve evidence. In fact, there are special procedural rules for ESI to make sure metadata is not deleted or tampered with. That's why defining the scope of discovery as early as possible in litigation is crucial. The duty to preserve evidence isn't triggered by the filing of the lawsuit. It begins as soon as the party can reasonably anticipate litigation. From that point on, relevant ESI must be preserved in its original, unaltered form. Failure to do so results in spoliation, which is defined as the failure to preserve relevant ESI or any deliberate change in ESI, such as erasing or changing it. Developed in 2005 by two Minnesota-based eDiscovery consulting firms, the EDRM, or Electronic Discovery Reference Model, is the industry standard workflow on which modern eDiscovery is based. It also serves as a guideline for corporate IT departments and their legal teams to ensure the company stored data remains discoverable if and when litigation arises. That's why it is especially important to follow procedures. The model consists of 9 interdependent stages. First up is information management, which is the foundation of the entire eDiscovery process. It involves implementing data governance strategies like classification, retention, and access control to reduce risk and cost before discovery even begins. Second is identification. Organizations must locate potential sources of electronically stored information. This step defines what data is in scope, its depth, breadth, and how it will be handled throughout the eDiscovery lifecycle. Third is preservation. Any ESI that is relevant must be protected from alteration or deletion. This includes setting up legal holds and suspending regular deletion schedules to ensure the integrity of the data. Fourth is collection. Once the data is preserved, it must be gathered for use in the discovery process. This is where the legal and IT teams begin acquiring data from live environments, archives, or third-party sources in a defensible manner. Fifth is processing. Here, data volume is reduced by filtering out irrelevant files and duplicates. Then it's converted into review-ready formats like PDFs or load files without compromising metadata or the chain of custody. Sixth is review. Legal teams assess relevance and privilege, identifying which documents are responsive to the case and which are protected under attorney-client privilege or other exemptions. Next is analysis. In this phase, data is contextualized. Teams look for patterns, timelines, communication threads, and other insights that might support legal strategy or reveal case-critical information. After analysis is production. This is when relevant, reviewed, and processed documents are delivered to opposing counsel or regulators in the format required, whether native, near-native, or standardized local file. The last step is presentation. Finally, selected ESI is presented in depositions, hearings, or trials to support arguments, confirm facts, or refute claims. The goal is to present the data in a way that is visually persuasive and factually clear, often preserving its original structure or metadata to underscore authenticity. Together, these 9 phases form a repeatable, defensible framework, one that legal and IT teams rely on to handle electronic evidence efficiently and in compliance with court expectations. Many ESI platforms already use machine learning and AI, most notably through a process called predictive coding, also known as technology-assisted review, TAR, or computer-assisted review, CAR. Predictive coding uses AI to develop a system that learns from human input and gradually makes faster, more accurate decisions about which documents are relevant to a case. It's a major time saver in legal review, especially when dealing with massive volumes of data. It all starts with what's called a seed set, a small representative sample of documents pulled from the larger review set. In AI terms, this is your labeled data. Highly trained attorneys or subject matter experts, SMEs, go through this seed set and code each document either as responsive, relevant to the case, or unresponsive, not relevant. These human-labeled examples are then fed into the predictive coding software, which learns patterns in the content, like text, metadata, and communication structures. This process is a classic example of what's called supervised learning, a foundational concept in AI where a model learns from labeled examples to make predictions on new, unseen data. I'll actually be diving deeper into how supervised learning works in an upcoming episode of my AI governance series, which you can find here. Now, there are 3 basic TAR protocols in use today. The first 2 are simple passive learning, SPL, and simple active learning, SAL, both associated with traditional predictive coding, also known as TAR 1.0. In these methods, we manually select a seed set to train the algorithm, which improves iteratively over time. Now, here's how it works. Simple learning involves rescoring the review set after each round. Once the model reaches an acceptable level of quality, you can consider it locked in. Here's the difference between the two. SPL uses a randomly selected seed set to train the model. SAL, on the other hand, starts with documents clearly marked as relevant or not relevant, and targets the gray areas, which is the ESI the model finds uncertain. The process reviews with the review set, which is a copy of all the collected documents pulled from the live system. From this, a seed set is selected. SMEs label these documents for relevance. This is what the algorithm trains on. At the same time, SMEs also label a separate group of documents, the control set. Importantly, the model never sees the control set during training. It's only used later to grade how well the model learned. During a round of training, the algorithm extracts features like text, metadata, and linguistic patterns to start building the classification model. Each document is given a predictive coding score, typically ranging from 0 to 1, estimating how likely it is to be relevant. Once training is complete, the model scores the rest of the review set, including the control set. But remember, the model is not privy to how the control set documents were labeled. This allows us to compare the model's classification against the SME's classification of the control set. That becomes our accuracy test. So, how do we know when to stop training? That's where statistical thresholds come in, often using metrics like precision, recall, and F-score to tell us how the model is performing and when it's ready to be locked in. For example, recall would let us know the proportion of actually relevant ESI identified. If our recall target was 80%, that would mean out of 1,000 relevant documents, the model must identify 800 of them. That would also mean it's missing 200 relevant documents. Or we could use a precision target that would tell us out of all the documents that were retrieved, how many of the documents were actually relevant. If the model identified 1,000 relevant documents, but upon review, you found 300 of those documents were false positives, then the precision rate would only be at 70%. These models are not expected to run at 100% accuracy, so it's up to the firm's discretion on which statistical thresholds work best for them. At the end of the day, there will always be a human in the loop to check AI's work. However, there is still another way to train these predictive coding softwares. The third TAR protocol is called Continuous Active Learning, or CAL. It's the backbone of second-generation workflows known as TAR 2.0. Just like it sounds, newly labeled documents are consistently updating the model's predictive coding scoring algorithm. The process is as such. Training begins as soon as a reviewer labels a document. That alone starts the training in the model. In essence, the system watches and learns from the reviewer's decision in real time. The software extracts features, such as text patterns and metadata, from the document and associates them with the assigned label, thereby scoring it. When the document is reviewed and labeled, the algorithm updates itself with this new information. As a result, previously scored documents may be rescored based on the evolving model. Unlike in TAR 1.0, there isn't a need for an SME to commit a ton of work upfront before the actual training begins. In TAR 2.0, the review team can be composed of junior attorneys with occasional SME involvement for quality control and course correction. The quality control done by the SMEs during the testing phase can also include illusion sampling. Illusion sampling is based on the idea that many documents in the review set remain unreviewed, meaning the review team has not labeled them yet. You could reasonably infer by the fact that they haven't been labeled that they're not as relevant as the others. So, to check whether the model missed anything important, the review team randomly samples from those documents to see if they can find anything relevant. If there are 40,000 unreviewed documents, and out of 400 there are 2 relevant documents, that implies a 0.5 illusion rate. Therefore, you could assume that there are still 200 relevant documents with the entire pool that you haven't identified. You can see here that the smaller the illusion rate, the better the model. Because of its higher recall and precision, CAL has become the industry's preferred method, but TAR 1.0 hasn't disappeared. In fact, combining these methodologies can achieve a more personalized fit to each legal team's needs. So now that we understand the hypothetical process, let's take a quick look at an actual eDiscovery platform. A collection of ESI here can be queried from a live data source or repository through the platform's API. From there, you can stipulate conditions for how the data enters the review phase. You might preview the data first to verify its relevance before committing it to review, or you might automatically copy and push the data into the review set, where it's deep indexed, meaning its text, metadata, attachments, and other features are extracted and made searchable. Once it's in the review set, you can navigate to a document and view it within its native viewer, again made possible through the API integration. Additionally, as you're accessing the review set, you can create filters to better organize the data. A filter simply narrows down what you're looking at based on certain conditions, like document type, custodian, date range, and prediction score. It's important to note that a filter is not the same thing as a label or a tag. A label is what the reviewer assigns manually, responsive or not responsive. A tag is an extra metadata field you can apply to describe an issue or a category. For example, you could tag something as confidential. And finally, the F-score is used to evaluate how well the model is performing overall. It balances precision and recall, so a score closer to 1 indicates the model is accurately identifying what's relevant and what's not. Back in the early 2000s, predictive coding systems in eDiscovery typically relied on traditional learning models, including logistic regression, support vector machines, and decision trees. These aren't the kind of AI models that dominate headlines today, like neural networks or LLMs. Instead, they're classic supervised learning algorithms that require carefully labeled datasets and structured training. If you're curious, I have a whole video on the origins of AI to explain where these models came from. You can take a look at that here. Despite their established use in other industries, predictive coding in eDiscovery was still seen as experimental well into the 2010s. Many legal professionals were hesitant to adopt it, not just because the cost and time involved in training, but also due to concerns over legal defensibility. Would a court accept machine-assisted document review? That skepticism began to shift in 2012 with a landmark decision in De Silva Moore versus Publicis Group. It became the first published judicial endorsement of predictive coding in the US, noting that such tools were not only acceptable, but could be more efficient and accurate than traditional manual review. Still, widespread adoption didn't happen overnight. As with any emerging tech in law, trust takes time. But here's the thing, you don't need to be a data scientist to use predictive coding. With best practices in place, it's a highly defensible tool. All it takes is a well-chosen seed set, a team of consistent trained reviewers, the exclusion of bias in training, and establishing an appropriate relevance threshold that makes sense for the case. And again, no AI is 100% accurate. That's why there's always a human in the loop. Training these models, even including LLMs or BERT, which I won't get into today, won't eliminate eDiscovery jobs. They're just here to augment our work and make our work smarter, faster, and more scalable. Now that we've seen how AI tools have reshaped the eDiscovery workflow, let's shift our focus to another way AI is changing eDiscovery. What happens when AI isn't just a tool in eDiscovery, but also a source of discovery? That is, what if a user's interactions with AI, like prompts and responses, become a part of the evidence? To answer that, let's review again what makes something discoverable. In US litigation, a piece of information is discoverable if it meets the following conditions under the Federal Rules of Civil Procedure 26b1. It's relevant to the case, it's not privileged, it's not unreasonably burdensome to produce, and it's proportional to the needs of the case. So before we move on to how this would apply to AI, let's draw an easy comparison here. How much of your browser history is discoverable? Turns out quite a bit if it meets those 4 requirements. Take a divorce case, for example. If one party visited dating websites or searched how to hide assets, that information could be fair game. The other party doesn't need a crystal ball to ask for it. They only need a plausible reason to believe the activity occurred. And plausible in legal terms doesn't mean certain. It just means credible or reasonable enough to justify further inquiry. So, what about AI prompts? Can they be discoverable? There's no bright line rule yet. But if a party used an AI tool in a way that touches on the facts of the case, then it's possible that AI prompts can be discoverable with sufficient justification, especially when they reveal intent, knowledge, or motive, just like browser history has been used in past litigation. Whether they should be discoverable, and whether AI platforms like OpenAI or Anthropic can be compelled to produce user logs, is a legal gray area we're only beginning to navigate. First, let's talk about relevancy. In both civil and criminal cases, it's defined the same way under the Federal Rules of Evidence Rule 401, which states evidence is relevant if it has a tendency to make the fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. It's a low bar, but the threshold on how the relevance is applied can look very different depending on the type of case. Criminal courts often deal with questions of intent, motive, or state of mind, which means digital evidence like search history can carry substantial weight. Take the case of US versus Segway, where the defendant's Google searches were admitted into evidence because they directly demonstrated his intent, an essential element of the criminal threat charge. If you've ever played the game Scrutinize, it works the same way. A character's search history helps the player infer what the person was thinking before committing a crime. In real life, courts use search data the same way to draw inferences about a person's mindset. Even though criminal defendants benefit from strong constitutional protections, including the Fourth Amendment against unreasonable searches, the Fifth Amendment against self-incrimination, and the Sixth Amendment, the right to confront witnesses, relevant evidence that speaks to the state of mind is still admissible if it meets the test. In contrast, civil cases apply relevance through Rule 26b(1) of the Federal Rules of Civil Procedure. Additionally, because civil litigants have fewer constitutional protections, courts emphasize procedural fairness and reasonableness when determining what discovery is appropriate. Take Marshall versus Dentfirst, for example. A civil court denied sanctions when the defendant failed to preserve browser history because the plaintiff couldn't demonstrate that the lost data was relevant enough to trigger a duty to preserve. This shows that relevance alone isn't enough. It also has to be proportional. Historically, discovery was defined exclusively by relevance, with privilege as the only real exception. That meant even highly personal or sensitive data could be fair game, even if it was marginally relevant. But over time, the scope of discovery has become more nuanced. First, it was the 1983 amendment that introduced proportionality concepts, asking whether the discovery was unreasonably cumulative, duplicative, or unduly burdensome or expensive. Then, in the 1993 amendment, the information explosion was recognized, thereby adding two proportionality factors. One, whether the burden or expense outweighed the benefit, and two, whether the discovery was important for resolving the issues. Yet courts weren't consistently applying these limits. That led to a major change in the 2015 amendment. That is when proportionality factors were finally moved into Rule 26b(1), not as a separate limitation, but as part of the very definition of what's discoverable. That's how discovery became to require both relevancy and proportionality. So where does privacy fit into all of this? In the past, private matters were still discoverable by default, even if they were only marginally relevant. But now, with privacy by design built into ephemeral communication tools like Signal, and regulations like the EU GDPR and the California Consumer Privacy Act, privacy is increasingly seen as a valid burden in discovery. Rule 34A(1) lends insight on how privacy should factor into proportionality analysis. When parties request access to systems or devices, courts often emphasize privacy as a burden. Direct access to a personal computer, for instance, raises serious privacy concerns, even if the data is relevant. For example, in Henson versus Turn Inc., the court found that requesting the plaintiff's phone was too invasive. It ruled that privacy interests must be considered on the proportionality analysis in Rule 26b. Also, in the In Re Anthem Inc. data breach litigation, the court warned of the Orwellian irony of forcing plaintiffs to disclose even more personal data just to seek relief for stolen personal information. These rulings show a shift. Private content is no longer presumed discoverable just because it's technically accessible. It can be a legitimate burden to weigh when deciding if discovery is proportional. So how will AI change this? User privacy should be absolutely considered when evaluating the discoverability of AI chatbots in civil litigation. Because users often rely on AI chatbots now to discuss deeply personal issues like medical history, mental health, and intimate relationships. Whether they should or not is a different story. The point is, these conversations are often more revealing than typical web searches, and they frequently occur on personal devices rather than corporate systems. So, can a civil court now demand access to a personal device to see AI interactions? In the past, courts have asked similar questions about search histories. In Heglet versus the City of Hayes, the court required preservation of internet usage logs since the plaintiff's unauthorized computer use was relevant to their termination. However, in this case and cases like it, the preservation of discovery was limited to employer-issued systems. Courts are far more cautious when it comes to personal devices, especially when relevance is speculative and privacy stakes are high. We're already beginning to see where AI interactions could be central to a claim. For example, malpractice or negligence based on the reliance of bad AI advice, misstatements or omissions that relied on AI-generated content, and fraud or intent-based claims where the user's prompt shows motive or knowledge. Imagine a situation where a user told an AI tool to omit key facts or rejected a correct statement in favor of a misleading one. That conversation might demonstrate intent. However, in the same way that AI could raise some novel privacy concerns, it can also help alleviate some of those privacy risks. During review, sharing large volumes of sensitive ESI among a large group of people on a legal team can be a massive privacy burden. TIR can help by reducing the number of human reviewers exposed to sensitive content, automatically identifying relevant material while filtering out non-relevant and potentially sensitive data. Looking ahead, AI could help mitigate privacy risks even more by minimizing the human review of embarrassing and deeply personal content. As AI becomes even more embedded in our daily workflows, courts will need to answer novel questions. Do AI interactions reveal a state of mind, like intent, motive, or knowledge? Is it technically feasible for us to preserve that data for future discovery? Are requests to access personal AI data too burdensome or too invasive? Should AI companies like OpenAI and Anthropic be compelled to retain and produce user logs? These answers will shape the next generation of discovery doctrine, where AI is no longer just a tool, but a source of truth. Thank you so much for watching. I know this video is a little bit more niche than the other videos I've been making, but I thought the topic was interesting nonetheless. So if you have any questions or suggestions, leave a comment below and also subscribe if you're interested in seeing more. Otherwise, I'll see you in the next one. Bye!